anticipating and overcoming impasse that the parties may run into during mediation settlement negotiations before those negotiations begin is an essential part of guided choice dispute resolution for one very important reason. And it's that sometimes there are key dispositive issues and sometimes even emotions that are so overwhelming that they impair the disputing party's ability to see past them, to get beyond them. For reasons of the way that our brains operate and the way that our emotions operate, and for human psychology and the way that organizations work and other factors, some of these things can be so overwhelming or receive so much focus that they completely hijack the ability of the parties to think beyond them. And it's certainly been my experience in mediation that sometimes parties are so hung up on one particular issue, and it may not even be what the parties wrote in their mediation submissions, their mediation briefs. It may just be a feeling of being wronged, or needing some catharsis to get something off their chest. There's so many things, okay, that can lead to impasse in mediated settlement negotiations, okay? It is that it's critical for a guided choice neutral working with the parties as part of the confidential discussions that he or she is going to have with the parties, as part of the process of getting at what might be impasse in settlement negotiations. When we start to discuss it, the role of the guided choice neutral in anticipating and overcoming impasse, or having an idea of how he or she might do it before the negotiation begins, is just so essential for guided choice dispute resolution, and really any kind of dispute resolution. And there are lots of ways to do this, but none of them involve what I'll call the traditional mediator's shortcut, right? I think one of the major flaws of traditional mediation is that a mediator is going to too quickly pick a date for the parties to come together and start negotiating, and the mediator is going to lead the parties to believe that a mediation is an event that happens on a day, and when the table is not set properly for that negotiation event, people leave angry, and it gives mediation a bad name, right? So there's a lot of ways for a guided choice neutral to anticipate, what might be impasse in the future and to overcome it. And I would say that, one of many examples, and this is just to try to make what might be abstract less abstract, would be for the neutral to say, okay, there's clearly something that the parties don't agree on. It might be, does one party have the basis for a motion to dismiss? Is it, the case that when we get into litigation, this is going to happen or that's going to happen, or, the parties disagree on some point of law? The guided choice neutral can carve out certain issues that are likely to be roadblocks, and refer them to an expert. Maybe it's a judge that is particularly knowledgeable, a retired judge, that might be able to weigh in on the issue, or it might be an expert that would be retained by the neutral or retained by the parties, for some sort of, binding or a non-binding assessment, and so this is suggesting the referral of certain legal or factual issues to somebody else other than the guided choice neutral. It could be another neutral. It could be an adjudicator, some sort of neutral evaluator, an initial decision maker, dispute resolution board, or submitting that issue to another process, some sort of a advisory mini trial, could be an option, as could be referring, that issue to be decided by a judge, the same judge that would potentially be involved in litigation if the mediation fails, for some sort of a declaratory ruling. I mean, there's nothing that would prevent the guided choice neutral from saying, okay, if one party believes that they've got a dead bang winner, in a motion to dismiss, let's just pause the mediation and let's proceed just through the pleading stage of negotiation, and we'll find out whether or not that party is right. And in the event that they're right, well, there's nothing else to discuss. And if they're wrong, then we can pause the litigation and come right back, into mediation. And even the suggestion of that process is something that could be constructive, to help the parties get past this. Well, yeah, I know I'm liable, but it turns out that you've blown the statute of limitations, so I'm not gonna have to pay you anything. It can be constructive to tee that issue up for a binding evaluation, or it could even be non-binding, right? I mean, one party might not love the idea of allowing a judge to resolve that key issue, if it could result in the other side getting a complete victory. And so the suggestion of this, might put some pressure on one party, and they might prefer that it be, an interim or a limited decision, without prejudice to taking the matter up again in front of the real judge, or the real arbitrator that would decide the case in the event that the parties are unable to settle. It might be a retired judge that just provides an advisory opinion, and the parties and the guided choice neutral can agree on all sorts of customization around these kinds of procedures that they would agree to anticipate and overcome impasse. The parties can agree on whether any information exchange or any evaluation that might be done by some kind of a neutral that might be involved by the mediator would be admissible, for example, in a subsequent litigation process or an arbitration hearing. So, I think it's essential that the guided choice neutral, have these confidential discussions with the parties in order to anticipate what might be the bases for roadblocks, what could cause settlement negotiations to crater, what's the source of these impasses, what would we do to get around them, and to engage the parties on this topic before they begin to talk about settlement dollars and to actually come together and to begin a negotiation. Because that's when, if there are dispositive issues or emotions that are really overwhelming the parties' abilities to think past them, when they come together and they start to negotiate at a traditional mediation event, that is when you pour gasoline on the fire. And if the party's ability to see past these issues hasn't already been hijacked, it can very much be hijacked. So you need to think through these things before the parties come together. And that's the point of all this. The thesis is that negotiations should only begin when the parties are ready to negotiate, right? When they have enough information for them to make a strategic determination about whether or not it's smart for them to settle now, or whether they'd have a better resolution to the dispute if they proceed ahead in litigation or arbitration. And this follows after the guided choice neutral engages in the confidential discussions with the lawyers and the business people. And when they're able to hear and to provide feedback on the guided choice neutral's diagnosis of what they think has caused the parties to get hung up to date, and the neutral's recommendation for how to proceed forward, and to get the buy-in of the parties, so that everybody can feel comfortable, not just with what's going to happen, but that they can feel like that there's a meaningful process that's been put in place that's customized for the particularities of the dispute. Because when you anticipate the grounds for impasse, and then before negotiations, there's an effort to overcome them, it empowers the parties to negotiate based on a process that they approve, right? And this is so important because mediation is essentially a voluntary method of dispute resolution. Anybody can get up and walk away at any point that they think that is what's in their strategic best interest. And in the event that you do wind up reaching impasse, in spite of best efforts to see how the dispute negotiation could fall apart, that isn't necessarily a reason to terminate the settlement process or to fire the mediator. The guided choice process contemplates, if absolutely necessary, if you're at a roadblock that you can't get past, not terminating the process, but just adjourning the mediation negotiation process while the parties figure out some other way to break through the impasse, right? And this, in many cases, is going to require them to wade knee deep into litigation or arbitration, or to do many other things that they could do, right? To seek these outside opinions from judges or arbitrators or experts on a binding or non-binding basis. But hopefully this would be done in a way that would allow the parties to control their costs and to get what they need, and to see an off ramp in the early stages of the arbitration or litigation before parties get entrenched in their positions or spend a lot of money or waste a lot of time on this scorched earth discovery, in zero sum motion practice, because this is typically what will drive people further apart. And if by the time they come to the negotiation, these key dispositive issues or emotions have not reached the point of being so overwhelming as to hijack the parties' emotions, if we're not careful, if you wade too deeply into litigation or arbitration, you can have this inflaming of passions, that would lead parties to want to fight even more, which, if it was the case that in circumstances like these, those parties actually went to trial at the end of litigation rather than settling on the courthouse steps, I could understand why it might make more sense to just allow the litigation process to play out. But because it is the case that most all design and construction disputes, even the kind that go through the nasty scorched earth zero sum litigation, uh, end up resolving on the courthouse steps before the trial gets started, it seems to me that avoiding a situation where the parties hit an impasse, and they have their passions inflamed and they feel like they've got no choice but to go through this hellacious, expensive, destructive process in litigation or arbitration, only to compromise at the end of the process after wasting a lot of money on legal fees. It doesn't make a lot of sense to me. So one of the key tenets of guided choice dispute resolution is engaging the neutral to anticipate what might be the basis for impasse and to work with the parties to create a process that might allow them to overcome those roadblocks that they're going to run into in the future, hopefully just in a mediation session, but wading lightly into litigation or arbitration if the parties agree that that would be a constructive way to exchange information or do whatever else it is that they think they need to do in order to make an evaluation about whether or not it is in their strategic best interests to settle the dispute.